Now, intellectual property rights, commonly we normally say that IPR. Now, these are legal rights. Now, in order to get an intellectual property rights, we have to first disclose that particular information to the government. Then the government grants you an exclusive right, which is a legal right. Now, when we talk about getting a legal right, now when we file a particular patent application before the patent office in India, we usually get a patent after it goes through a series of process. Like, once you file a patent, then there is publication, there is examination. If someone objects, then later on it can get into the prosecution stage, and later on, after clearing all the objections, then you are being granted a patent. So you're given a particular legal right, but this particular legal right is given to you only upon disclosure of those of about that invention to the government. And when you get this particular legal right, it's like an exclusive right given to that particular inventor. So in a way, it protects his inventions from others from being using it or exploiting it or selling it. And what happens is that this particular kind of an now I'm talking about an invention, but similarly, intellectual property rights, these rights can also be given for industrial designs, scientific work, literary, or artistic fields. When you talk IPR rights, it's always having an exclusivity. Second is territorial. Now, when I file a patent application in India, it's going to be, once the patent is granted, it's going to be protected within the territory of India. So it's territorial. It is time limited. That means once I'm granted a patent, maximum protection you get it is for 20 years. And the most common IPRs include, one is patent, copyrights. Now, copyrights is, again, it's not for an idea, it's for an expression of the idea. Like for patents, not for the idea, it is for the embodiment of ideas. Like copyrights, not for the idea, but for the expression of ideas. Trademark is something that helps us to identify a product. Trade secrets is the business, confidential business information, and design is something what we call appearance, the shape. It's not a fun aspect, but shape, the touch. When you touch a particular product, you know that there would be some grooves, there would be, it gives a different feel when you touch a particular product. So that comes under the designs. Now, when we talk about patent, there are a couple of examples are like when you talk about safety pins, screwdriver, it leaves that. Trademarks, it could be name, the symbol, slogan, or the combination. Copyrights, like for music, photograph, architectural works, and books. Trade secret, as I already mentioned, is the Coca-Cola, which, the trade secret of Coca-Cola is a chemical formula which is not known, and that gives them the competitive edge in the market. I've already discussed this earlier also, that inventions and creations begins with an idea, right? Then the idea is converted into an actual product or a creation. That is what is protected when it is getting converted from an abstract form to something that you can see. Gets registered. When you apply to the patent office or a copyright office or a trademark registry, that particular thing, if it is a trademark, it will be registered before the trademark registry. If it is a patent, if it's an invention, it will be registered before the Indian Patent Office. If it's a copyright, it will be registered before the Copyright Office. If it is designs, then designs registry. and it gets registered and it is protected with the government. It grants various rights called intellectual property rights. Like any other property, even a person who's owning an IP, they can rent it out, they can give it to someone, or they can sell it, just like how you normally deal with other properties. Like, you can license it out. There could be a cross licensing, there could be an in-licensing, there could be an out-licensing. And these are like, we will be talking about in-licensing, cross-licensing, these are something that is normally used at the commercialization level, like, when you start commercializing the IP. Intellectual property system. When you talk about intellectual property system, it talks about rights, the obligations, like the privileges and the incentives which is granted by the system. And all this is rooted, or it arises because of some creation, or because that particular inventor or that particular creator of that particular artwork has decided to protect that IP. So when they want to protect it, they will approach a particular system that will take care that it is protected and the person enjoys the protection of his IP work. Now, what is the commercial importance of intellectual property? And when we talk about the commercial aspect, it enables people, whoever is the inventor or the creator of a particular artwork, it helps them to earn. They can commercialize their invention, and through that, they can earn money. It gives them recognition, because when a person is granted a patent, um, usually, suppose if the applicant is also the inventor, suppose I am a researcher and I have invented something, I've filed a patent. So I decide to file it through a patent attorney. So I will be the applicant, I will be also the inventor. Suppose I am a researcher working in the university premises. So I'm more like a researcher who is being paid, remunerated by the university. So I'm more like an employee of the university. And if I do a particular research, there could be an employment agreement, or there could be a kind of a contractual agreement between the university and the researcher, which might say, like, or it might be already an inbuilt clause in the employment agreement which says that if I'm going to do anything related to research and I come out with any kind of an invention, then the university will be the person who would be entitled to my work. I would be the inventor. So, in such a situation, the university would be the applicant, and the inventor will be the person who has done the invention. And by which this particular university becomes the applicant is because by virtue of that employment agreement or the contractual agreement signed between the researcher and the university. So, in a way, it gives you recognition. When a particular university has so many patents to their name, or a particular pharmaceutical company has so many patents, it automatically adds its value in the market of that particular company. And of course, their product also will be given a much higher, value or recognition in the market. There's always a financial benefit, there's always a recognition, and it also aims to foster a balanced environment where you can, in which creativity and innovation can flourish. So like like when someone has already got a patent, in a way, it actually promotes more people to innovate something, and kind of a more of a environment is created where innovative ideas will flourish, and more people will come ahead and try to patent their inventions. It also acts as an instrument of development. Especially, they are the key drivers of economic performance in R&D based growth models. It also actually do affect the extended nature of investment. The moment, like when you have your IP very well protected, and when you actually speak to your investors, they like to know how good your IP is, and that actually attracts investment. So to a great extent, it affects the investment aspect too. Now, it also helps consumers find and identify their products. Now, when you go to the supermarket, on the shelf, you try to just check for the products you love to use or you're happy with it, but you recognize a particular product by its brand, or what you call as a trademark. You look at a parachute and you say, okay, this is the oil I use. So you recognize your product by the trademark. It generates more employment by creating new jobs. Now, we will come to this aspect when we talk about IP management. It improves the economy of a nation. It's always nice when a country has a lot of patent. In a way, it actually boosts the economy of a particular nation. It also kind of generates more employment. Now, reasons for the importance of IP. Now, why do we need to promote and protect IP? Why there is so much of talk that goes around that we need to promote IP, we need to promote innovators to come up with new invention, and why we need to protect IP. The IPRs create incentives and awards for artists, entrepreneurs. It promotes inventors to research, develop, and market new technology. IP rights allows artists and inventors to have control over their creations and inventions. Now, control is very important aspect. When you have your patent application filed and then you're being granted a patent, so you have a patent to your name. So tomorrow, what happens? You have an absolute control, exclusive control, like whether you would like to license it out or whether you would like to develop the particular product, you kind of gain a little bit of a monopoly if it is something a really good invention. Safeguard novel and advanced innovations. So it's a way it protects the novel ideas and advanced innovations from being, copied by someone. And also it ensures, in a way, like a person who is a researcher who spends sometimes a decade or years together to work on a particular invention and come out with very very good results that is going to benefit the society, or it's going to bring a different dimension altogether in the industrial sector, then definitely at the end of the day, the person who has worked so many years on that particular invention has to be rewarded or has to be appreciated or has to be compensated for that particular effort. So in a way, when you register a particular patent, it always rewards or kind of gives a recognition to that particular inventor. Now we'll go step by step: patent, trademark, copyright, designs, and trade secrets. Now, under patent, when you get a patent, it excludes others from making it, selling it, or using their inventions. And when you talk about an invention, it has to be either a new product or a process, or it could be a technical advancement over the existing knowledge. That means, suppose you know about a particular engine, you know that there is an engine, and especially in the automobile sector, automobile industry, you know that the car works because of an engine. Each company will have its own kind of an engine. But suppose someone comes with an advancement on that, which might improve the mileage aspect or any related aspect of it. So it's a technical advancement. It might not be new, but it is an advancement to the existing knowledge, or it gives some economic significance because of that particular specificity in the engine. It actually has an importance from the economical aspect. Or it could be there is a technical advancement as well as economic significance. Both will be there. Now, when we talk about invention, suppose a researcher has come up with a good invention. And the first thing any person would have to look into is you have to check whether it's patentable or not patentable. Now, under the Indian patent law, there is a provision where it is very well listed what is not patentable. So it's like the first filter. You need to just, kind of put your invention through that particular filter and try to understand whether it's patentable or not patentable. If it's not patentable, it's out of the, there is no point in going to the next step. But if it's patentable, then you go to the next level. Okay. Then you have to know that it is something new and it is not already existing in the public domain or anywhere in the world. Okay. The moment once you check whether it's patentable, then you have to check whether it is new. I'll go to the next slide so that. Once you cross that particular filter wherein you come to know it's patentable, then there is another 3 principal requirements for inventions to be protected. First, it has to be novel. A new characteristic not known in the body of existing knowledge, that is in the prior art. That means nowhere it is existing, this particular knowledge is not existing. Second is the inventive step. It should have an inventive step and it should be non-obvious. And non-obvious is very important. That means any person who's having a knowledge about it, from that respective field, should not be able to, easily deduce it or come to a conclusion. It should be something that is not very obvious to a person well learned from that particular technical field. Third is industrial application or utility, whether it is of some practical use or it is capable of some kind of an industrial application. So these 3 aspects also will be checked before you go ahead with, processing the patent protection. Start with the process for patent protection. Now, as I've already mentioned to you, that it is for 20 years. You give a license or ask for a fee or royalty from those who want to use your invention. That means, suppose many a times what happens, an inventor, he must have invented a very good thing, but maybe he doesn't have the logistics to manufacture it, to develop that particular product or use that particular technology. Then there are people who would just come and negotiate with him, deal with him, and take that particular product, take that particular invention on a license, or they would charge, they would pay that particular person and take that particular invention, and they will later on develop it. Or there is another deal which the inventors usually strike, is that they tend to get royalty. Like if suppose someone is ready to develop that particular product and sell it in the market, as per the sale, they get a royalty. So there are different kind of ways they try to negotiate with those from the commercial point of view, and get the fee or royalty, or it could be a one-time settlement amount, whichever is comfortable for the inventor and however he has decided to deal with that particular patent. These are the few landmark judgments with regard to patent. One was a Novartis versus Union of India, wherein a rejection of a patent for a drug because it was not inventive. Because this particular case, they actually, as per the particular provision, that is Section 3 of the Indian Patent Act, they rejected that patent application because they didn't find that it didn't have an inventive step, or neither it had, something. They gave a very good reason with regard to the superior efficacy. And there is Bayer Corporation versus Union of India. This was India's first case where there was a compulsory license granted. Now we'll come to trademark. Okay, let me tell you one more thing about patent is that when you talk about a patent document will be like, it consists of two parts. The first part is where you disclose the details about your invention. And the second part is the claims. Now, claims is that aspect, that particular place where you define the scope of your control, that what you want to protect in your particular invention. Now, trademark. Now, trademark is something what we call as a recognizable sign, symbol, or expression. It helps a consumer to identify a particular product or a particular service. It can be a word, name, sound, numeral, color. It is usually registered. Once a trademark is registered, it is registered for 10 years and it can be perpetually renewed by payment of a corresponding fee. So when you're about to end, complete your 10 years, just before completing, you have to apply for a renewal process, and you can again get renewed by paying respective fees. These are the common trademark. Now, the moment, suppose a trademark agent has been approached by a particular proprietor and he decides to register his trademark. The moment the trademark agent files an application to register a trademark, you can use TM. That means it is not registered, but you have started the process of filing for a trademark. The moment it is registered, then you can put R and you can circle it. So whenever you look at particular products, you will see TM. That means the application has been filed and it is in process. The moment the trademark is registered, you can put an R and you can put a circle. The same thing works for unregistered service trademark. If it is in the process of filing, in the process of getting a trademark, then you usually put ESM. Now, when we talk about copyright, it protects the literary and artistic works. Now, when we talk about computer programs, even computer programs are copyrighted. Now, that is computer programs per se, it is usually copyrighted. But if it is embedded with the hardware, then it can be a subject matter of patent. But computer programs per se, it is only copyrighted. Design. Now, when you talk about registered designs, it usually protects the look of a product or a part of a product or even the design of a detail in a product. And you can also license or sell a design. Trade secret, as we discussed, it is confidential business information which gives a competitive edge in the market. It can be a formula, it can be a patent, it can be a commercial secret, it can be a commercial method. But in case of a trade secret, there is no disclosure. Okay? But suppose what happens is another competitor, he decides to do a reverse engineering and he somehow comes to know how it is being done. Or he independently works on it and he finds and he makes an invention. Then he can go ahead and he can get it registered. He can patent it. And then it would be a problem for a person who has not registered and is maintained as a trade secret, because trade secrets are usually not disclosed. Whereas for a patent, what happens? Disclosure of your invention is a must. Now we will come to the main topic, that is a startup. Now, the Patent Amendment Rules 2016, they define startups as entities which works towards innovation, development, deployment, or commercialization of new products, processes, or services driven by technology or intellectual property. And it was for more than 5 years, have not been lapsed from the date of incorporation. Registration with a maximum turnover of rupees 25 crore per year. Now, this is how the startup was defined as per Patent Amendment Rules 2016. Now, the Patent Amendment Rules 2017, wherein a startup can be any Indian entity recognized as a startup by a competent authority under the Startup India initiative, or a foreign entity that fulfills criteria for turnover and period of incorporation registration as per Startup India initiative. Now, what are the criteria? It could be like incorporated as a private limited company, or registered as a partnership firm, or a limited liability partnership in India. It could be like incorporated or registered in India not prior to 7 years. If you look at the 2016, it was 5 years. However, for biotechnology startups, not prior to 10 years. The turnover not exceeding 25 crores. It should also be that it has not been formed by splitting up or reconstruction of a business that was already in existence. And the last is working towards innovation, development, or improvement of products. Now, this was a criteria to consider any entity as a startup. And what are the benefits that has been given by the government? The government of India, they have come up with a lot of government schemes to make this patent procedure very friendly. And because of that, they've come up with patent-friendly schemes and policies. Now, the startups are eligible for benefits such as 80% rebate on patent fees, and the department, that is the IPP, actually on behalf of the startups, they bear this cost and provides rebate in the statutory fees for filing applications. Like suppose if it's a private limited company, it has also a startup certificate. The moment when you file even for a trademark, usually for a company a private limited company, it is usually 9,000 rupees, which is a statutory fees. But the moment you say it's a startup, it gets 50%. The fees become 4,500. So that's how they get a little bit rebate as far as the statutory fees are concerned when it comes to filing of trademark applications or patent applications. Now, another aspect which is very, very important. Now, suppose if I'm an individual and I go and file a patent application in the patent office, I have to go through that process. It's quite a tedious process. It's quite a lengthy process, and it takes a lot of time. So, but when it's a startup, they have something called early publication. The moment, as a startup, they can move an application asking for early publication, and they can get it published within 1 month from the date of making such request. So it's more expedited process. Okay. And what happens when there's an early publication, there is an early examination. You can also move an application for expedited examination. So when you try to speed up the whole process, you can get your product patented faster. So in a way, you have a better edge than the competitors. You can enter into the market, you can commercialize it, you can develop the product, and you can really, capitalize on that invention, and you can make a lot of money. So that's an advantage of being a startup. Now, when you talk about a startup, there could be some kind of intellectual property issues. Okay? Now, anything with regard to a startup, especially if it is related to technology, IP will be an important asset for them, because that is going to be the core asset of that particular company. So for them, there are a couple of issues. Like one would be developing a particular product, hiring qualified professionals. That is also an important aspect which a startup should look into. investment or raising capital or funds. So they need investors, they need to develop the product, they need to hire qualified professionals. So it means you need a lot of money to build up, build up with something, um, a strong setup. Now, IP strategy or IP management, it's always may sound very, very expensive, and it's time consuming. When you go for a patent, it takes time. And even if you go for a trademark, if there is an objection, then there is, it is not something that you just file it and you get it the very next year in 2 months. It takes some time for the entire process to go as per how it is, already laid out. But when you talk about IP strategy, first of all, it's very expensive. Second thing, you have to launch the product in the market and have an upper edge. And then at the same time, you have to make sure you get your IP protection done. So first of all, it's expensive. At the same time, you have to launch the product, which also requires money, marketing, all those things. So, it's kind of a thing where you have to take a very, very good decision. There should be a lot of due diligence taken by the company key persons as far as the IP issues are concerned, IP protections are concerned. Now, from the business perspective, when you file a patent, it helps in driving investment and acquisitions. It provides protection during partnership and business deals. It helps defend itself against patent lawsuits by others. What happens when you file a patent and your patent is granted? In a way, if you look at the whole aspect, I suppose if whatever your technology is or invention, if it is not patented, there are more chances that tomorrow there could be a lot of lawsuits against your company for violating someone else's IP rights. So once it's protected, there are less chances, having issues and, legal suits which you have to pursue or which the company has to pursue. That itself is another expensive process. In the long run, if you see, like, when it comes to IP management, if you invest, if you, in a very diligent manner, if you invest your money in IP protection, in the long run, it always saves you from a lot of legal issues with regard to lawsuits, with regard to infringement cases, or violation of any other company's IP rights. If you see from, if you compare it, in the long run, you end up spending more money if you don't protect your IP at the very initial stage. Or suppose you just imagine, like, you entered into the market and your product is known by this particular name, and your product has actually gained momentum in the market and it's absolutely doing well, but you have not registered that particular mark, and after 2 years you realize that someone else has already registered it. Now you have to then you have another option of knowing your same product with some other name. That's really going to cost you a lot when it comes to the market strategy. So, it's always nice to invest when you know that this is your core IP, it's your important asset. Then you have to make sure that it is very well protected so that in the long run, it doesn't thwart your business activities. Now, when it comes to a startup, there will be a lot of people who are working and they'll be working on different aspects. And every startup should have a simple process called as an IP harvesting process. It should be divided into 3 steps. Like, first, a disclosure. Once, suppose someone is working on something and they disclose, okay, this is my invention. Then there is a review. Then you see whether it is enforceable, whether it is worth protecting it, whether it will be really a core IP asset of the company. And on that basis, you decide to go ahead with the patent filing. Now, in the disclosure stage, employees who are in IP creations, who are busy working on something new, innovative ideas, they must be trained. They should be made well aware of the fact that they have to disclose the ideas that are very, very important, or it could be a potentially protectable IP. Now, every startup uses all these things like trade name, brand, logo, advertisement, inventions, designs, products, or website. And if you go to see, all above possesses valuable IP rights. If it's a consumer product, a brand, trademark, logo, advertisement makes a lot of sense. But if it is like, suppose, a technology-based startup where they work on software programs, so you can copyright certain software programs. Suppose if it's a pharmaceutical company, they've come up with some invention, uh, then it has to be patented. So you have to know what kind of work your startup does, and accordingly, you have to prioritize what is important for you to protect first. IP management. Now, one of the requirement and reason for protection of IP is to get capital funding and to prevent unfair competition with competitors. And when we talk about IPR management, first is like you look at a potential. There is an invention, and you see that there is a potential in it. Then you evaluate it. When do you do the evaluation? Is when you try to disclose it at the disclosure stage. Then comes the IP protection. Once it is disclosed, you understand the value of it, or when you know the it is something that is in the long run really going to be very important for the company. It's an important asset for the company. Then you decide to go ahead with IP protection, and then is the implementation, what we call as a commercialization. And this IP management comes in that stage where you want to commercialize that particular IP. When we talk about IP management, like first, as you said, like the idea, invention, disclosure, patent filing, and then the grant of a patent. And then you try to value that. There is something called value proposition. You try to understand the value of that particular patent. Now, when you talk about patent filing and grant of a patent, you have to check cost factor, because when you file for a patent, it's an expensive process. So the cost factor is important. So you need to understand the cost factor involved. So when you try to see, okay, there is an invention, you have to see, I'm going to spend so much of money to protect it. Whether it is going to give me that kind of a value at the end, you have to do that comparison very well. Then once the patent is granted, you have to check whether it's enforceable, whether it has any industrial utility. Now, for any startup or any company or any corporate entity, they have to first know their IP. And they should have a person who manages the IP, or a particular team that should work together to protect it. You have to know where your IP is stored or processed. It could be in the devices like output, input, cloud application, file sharing services, or personal devices of staff, third-party systems. So even personal devices, even if a staff could be taking in his own personal laptop, home, then you have to learn to prioritize your IP, mapping the company's assets. Then you have to label valuable IP, which IPs are very valuable to you. Then you have to take steps to secure it physically or digitally. That means you try to limit it, limited access to that particular sensitive data by employees. Like suppose if there is a team who works on a particular application or a particular process or a particular method, and they will be dividing it into different teams. One team will be doing this aspect, the second team will be doing another aspect, the third team would be this thing. They all together might not be doing the entire thing. In a way, it gives them a limited access. So nobody knows the entire thing. So it's another method of trying to secure your IP. Educate the employees that they should not share the confidential information with any third party. Develop tools to protect your IP. Then the registration. You can register and protect it from any other third person to the other person to use it or make it. Due diligence of IPR by startups. They have to make a decision, like, if it is a tech and what they feel, okay, whether they should copyright the software program, or it is a software program embedded with hardware, then whether we should uh, do a patent, file a patent, whether it's a consumer product, whether we should just try to get a trademark registered and make sure that this brand is promoted. Then the implementation of effective policies and protection strategies. Then agreements. It's very important when you have a startup and when you start hiring your employees, you have to do a thorough check on your on the staff that is being recruited. You have to check whether they have been working earlier with any of their competitors, um, any of your competitors. Second thing, you should have in your employment agreement a confidentiality clause, which is very, very important. That binds that person from non-disclosure. Third thing, when the person leaves that particular job, he should be able to hand over all the IP related materials. If he should not keep a copy of anything with him, like, and he should give it in writing that he is not keeping any of those material with him, which is, a copy of it, or he should make sure that he destroys all that, so that that confidential information of the company is not being carried along with him once he resigns or is being terminated from, or his employment is being terminated. Then even when you sign a contract with any other parties, it could be a third party who's helping you. It's kind of, or even to those parties whom we are licensing it out. Even with them, you should have agreements which clearly, has clauses that protects your IP. Now, managing the IP. Now, important to access first is like when you consider IP issues, just like as part of your business strategy, because your business runs because of your IP assets, which your company has. So IP issues has to be just dealt as if how a company would deal, or consider any of their business strategy. It should be given utmost importance. At first, there should be an in-house competence to manage your IP issues on your own. That means you should have a person who is well versed with IP laws, who knows about the core IP assets of the company. He should be able to manage the IP issues. Second, you have to identify every possible asset in your company. And then you have to check if you might be having 10 possible assets in your company. But maybe all the 10 assets might not require protection. So you have to identify which assets need that protection. Now, there's a priority which is more important for you at the moment. So you put in the money over there. And once you start getting some good revenues, then you can decide to protect the remaining findings. You have to see from your findings or discussing with your team, which is really worth protecting. And then you have to also compare the potential gain that you will expect to get from the assets against expected cost. You might put a lot of money in filing a patent, but you are not getting anything, much potential gain. So you have to analyze that aspect as well. Then choose right forms of protection of assets. You have to choose the right method to protect it. Then decide what to protect and ways of protection, how you will protect it, and the ways, what you will protect and by which way you would be protecting it. Whether you would be doing a trademark filing, whether you would be doing a patent filing, whether you would be doing a design filing to get a design registration. Then you have to also check when you are trying to protect something, you have to take a very strong decision on the cost to value basis. What is the cost involved and what is the value you are getting for protecting it? Then once you discuss all the key factor, then you start the process for actual protection. Once you're sure about, okay, this is really important and I need to get a strong protection for it. Okay? Raise financing, and that raise finance, that is financing from private investors. Once you know, okay, always remember whenever you want to disclose something to any investors who's ready to invest the money to develop a particular product, you have to always file your patent application first and then disclose it. That's always a right approach. And remember, whenever you're doing all this process in managing your IP, the most important thing that needs to be taken into consideration is that your company or your startup should have all the policies and procedures well in place, because for you, the most important asset of your company is something that is dealing with ideas or something which invention. So it is very important that a third party does not have an access to it. There should be a complete confidentiality that needs to be maintained at all levels or at all steps. Okay, so you have to make sure all your documents, that is your contracts with your company staff and partners, employment, that is with regard to the employment agreement. If there is a partners, you have to have a contract with them. If there is a joint owners, work order contracts with the third party, all needs to be drafted, signed, and get all those aspects very clear with your employees, with your co-partners, with your third parties who are going to be working with you. Thank you so much.
Thank you, ma'am, for such a lovely session. Now we have some time for question answer session. So we have 2 questions in our chat box. In fact, 3 questions. So if there are any more questions, now is the time to ask. Or I will share the link. I will share ma'am's email ID on this chat box, so as to any of you having more questions could ask the questions via email. Okay, so the first question to ma'am is by Roshan Ratnakar Naik sir. So he has asked this question: can second medical use of drug be patented in India? So ma'am, I request you to address this question. Can second medical use of drug be patented in India? In other words, if an existing drug has a novel mode of action, can it be patented under second medical use?
Can I have a little more clarity on this particular question, please?
Yes, I request Roshan sir to ask the question via use on the mode itself, on the Google Meet itself.
Yeah, it's about so there is a drug out there, and we have researched its another mode of action. So, but I'm not sure if it can be patented. So in that this is not the mode of action.
I'm not able to hear you properly. There is a slight disturbance. Could you just please repeat it?
So can I ask you directly? So it's me. Can I ask you directly? So, so there is a drug which is used for treating brain disorders, and so the pharmacokinetics everything. So there is a drug which is known to treat for brain disorders, and so the pharmacokinetic information is available. And we have seen its effects also on other disorders like obesity. So I'm not sure if it can be patented in India. So it's the second use.
So you mean to say like it has a impact on the human
Yes.
body.
So the drug is used to treat certain brain conditions. But so now we have also seen its effect in obesity conditions, metabolic disorders. So I'm not sure if we can patent it as a second medical use category.
Um, I would really need to check on this one aspect, but if you could just show, like when you're filing a patent on this particular aspect, you have to first show, you have to give an idea like what your drug is, one, and you would be trying to compare with the previous drugs, how it is having a better effect. You have to show in what way it is much better than the previous drugs which is already available in the market. So what is that drawback that your drug is uh, trying to overcome? So what is that best part of in your drug that will have a better edge or effect than the previous drugs? So you would be given only the patent for that. You would be putting your claims. Once you disclose your invention, you would say like, okay, my invention is this and how it is better than the previous drugs and how it is enhancing certain things. Then you would be given only for that aspects.
Ma'am, I have another question. For startup registration, is proprietorship or a private limited is a better option? Is if someone is starting in the beginning,
So you just please repeat.
proprietorship, proprietorship or private limited would be which of the options would be better for startup registration?
Um, Now, you said whether it's a proprietor or whether it's a company limited. Now, if it is a proprietor, it's just like a single person who does it. And the fee structure would be different. When you're filing for a trademark, it would be 4,500 if it's an individual. He will come under the individual category. If it's a private limited company, then definitely you have to follow a lot of process, like you have to get your incorporation certificate done, then you have to have minimum 2 directors. Then there are a lot of compliance which you need to do, like get yourself registered. Then, and plus, when you're filing for a trademark as a private limited company, your fee structure would be different. The statutory fee while filing a trademark application would be 9,000. But if at all you manage to register your private limited company as a startup, then you would get a rebate, which is as per the Government of India scheme. That particular, you can avail that particular scheme. And of course, if it's a private limited company and plus it's a startup, then when you're filing a patent, especially for a patent, you get those benefits like where you can apply, where you can put in a request for an early publication, you can expedite the examination. So what happens, the whole process becomes so fast and you can get a patent much faster than an individual filing it. So there is advantages in terms of filing as a if your company is registered as a startup. Even nowadays, many people go for LLP also, limited liability partnership. Any more questions?
So, ma'am, I have shared your email ID on the chat box. If in the chat box, if any of our participants have further questions, so I don't see any more questions. So I request all the participants to fill the feedback form to receive the certificates, which will be done at the earliest. And we are coming to the end of today's session. And as a member of Team IIC, that is our Institutions Innovation Council, I thank Ma'am Rejitha Rajan, our resource person for today, for such a lovely session on IPR. Ma'am has thrown a lot of light on protection of our invention or any innovation. She has also spoken about trademarks, copyrights, patenting, uh, ideas for branding, also about landmark judgments, and so on. So today's session has really been resourceful, and I'm sure all of us have gotten to learn something new from today's session. And I take this opportunity to thank ma'am from the team IIC, and also to thank all the participants who have spent their time and who have attended today's session. So I thank all of you, and I hope to see more cooperation for the future sessions that we will be organizing from Institutions Innovation Council, Dhempe College of Arts and Science, Miramar, Goa. So take care and have a nice day. Bye bye.
Thank you.